and welcome to Dicentra's Regulatory Update webinar. My name is Ann Wilkie, and it is my pleasure to be your presenter for today's webinar. Today's webinar will focus on activities that have happened in the third quarter of 2010, and we should last about 30 minutes. Dicentra is a leading international scientific and regulatory consulting firm with specialized expertise in the areas of natural products, dietary supplements, over-the-counter drugs, foods, and cosmetics. For more information, please visit our website or contact us by email or phone. We are pleased to be able to present these webinars free of charge to industry stakeholders as part of our ongoing commitment to industry education and our support of the natural health products regulations. The objectives of today's webinar are to help ensure that you are current with the regulatory requirements for selling natural health products in Canada and that you are aware of other policies and procedures that may impact your ability to do business in Canada. Over the next 30 minutes, we'll look at changes in regulatory initiatives and associated policies, the status of applications, quarterly report, new guidance and tools for published product and ingredient information, activities of the National Health Program advisory communications, and sum it all up. So the topic we're going to be looking at is regulatory initiatives and associated policies. So I'm sure you can guess that the main topic of conversation over the last few months has been the actual promulgation and implementation of the natural health products process product license applications regulation. Previously posted on our a lot of people about it, the implementation of law. Law provides some measure of 2,000 product pending review and licensing by the Natural Health Products Directorate. Some of these applications have been waiting for a licensing decision since 2004. UPLAR came into force on August 4th of this year, and you can see on the slide there is an actual link to the publication in Canada Gazette Part 2. When the regulations came into force, they were not yet published in the Canada Gazette. So UPLAR allows for products that meet certain criteria to be issued an exemption number. With an exemption number, a product is deemed to hold a product license and is therefore legal to be sold. The criteria that must be met in order to apply for an exemption number: you must have submitted a complete product license application to the Natural Health Products Directorate. That application must still be in queue. It must not have been withdrawn or refused. As well, your product cannot meet certain risk criteria. Specifically, if your product is a sterile product for ophthalmic use, if it contains certain prohibited substances under the Food and Drugs Act and regulations, if your product makes any Schedule A claims, those claims for diseases that require practitioner or physician intervention, if your products are for children under the age of 12 years or for pregnant and nursing women, or if a product contains an ingredient subject to a stop sale or recall, you cannot apply for an exemption number. So therefore, as well, your product must have been in queue for at least 180 days from the date a submission number was issued. So again, in order to apply for an exemption number, your product there must be a complete application in queue. The product must not meet any of the risk criteria previously mentioned, and the product must have been in queue for at least 180 days from the date the submission number was issued, without a licensing decision having been made. As of this morning, there were 7,182 products with exemption numbers that are in the exemption number database. And again, you can see the link there on the website where you can find this database. It's important to note that a product is not deemed to hold a product license until the information about that product is posted on the website in the database. Within that database, you'll find the exemption number, which is your submission number preceded by the letters EN. Your company name will also show up there, as well as the brand name of your product, the dosage form, the status of the exemption number, whether it's valid, not valid, or a license has been issued, and the date of that status. Again, it's important to note that applicants must apply for an exemption number. So for applications that were in queue when the regulations came into force, there was a notice sent out to them and a fax back form attached. For those products that don't have submission numbers, there's a different fax back form on the website. So again, it's up to the applicant to apply for an exemption number. You have 60 days from the date that you are eligible to get an exemption number. So once the 180 days has passed from the date you got your submission number, you have an additional 60 days in which to notify the NHPD that you wish to get an exemption number. If that 60 days passes and you have not notified the NHPD, then you will no longer be eligible for an exemption number for that specific product. So if we just go back to this slide, you can see that yesterday was the deadline for opting in for products that qualified, for products that had met the 180-day requirement as of August 4th when the regulations came into effect. They had until yesterday to apply for an exemption number. So for products that met the 180 deadline on August 5th, today would be the date, the deadline to apply for an exemption number, and so on. So each day from here on in, there'll be more and more products eligible to qualify for an exemption number. Again, as I say, it's important to note that it is up to you to apply for an exemption number. The NHPD will not tell you that it's time. For those products that are that you are submitting now, you can preemptively opt for an exemption number. So when you are submitting your product license application, you can fill out an exemption form that you can find on the website, and you can submit it to the NHPD. When you do that, then you'll automatically be granted an exemption number on the 180th day if you've not yet received a licensing decision. The information will automatically appear in the exemption number database. If you wait, you submit your product license application and you don't submit a fax back form, when the government reviews your application for completeness and gets back to you with an acknowledgement letter in which there's a submission number, they will also tell you how you can apply for an exemption number and when you are eligible for an exemption number. So as I say, there's two versions of the fax back form. One would have been emailed out to stakeholders for those products that had submission numbers already when the UPLAR came into force, and another fax back form that you can find on the website for those products that do not currently have submission numbers or have not been submitted yet. So again, the things to remember, make sure the application is complete. If it's not complete, it will be refused and you'll have to try again. Other things to note, you can make your product eligible for an exemption number by removing risk factors. So if your product is targeted for children and adults, you can remove the subpopulation of children under 12 to make it qualify for an exemption number. If you've got a prohibited ingredient in there, you can reformulate it to remove that specific ingredient. As well, if you have any Schedule A claims or unacceptable claims on the product, you can remove those claims. So in order to qualify, you can remove risk factors, whether they be claims or ingredients or subpopulations. You just need to notify your submission coordinator of your intent to do this, submit a revised product license application as well as the revised label text. So obviously there's benefits to applying for an exemption number. It does make your product legal for sale. It is recognized by the National Association of Pharmacy Regulatory Authorities, where a majority of this all started. They were advising their pharmacy members not to sell products unless they were licensed. They have amended their position statement to say you shall not sell products unless they have an exemption number or a product license. So an exemption number, an actual product number, a DIN or a DIN HM. So definitely a benefit to applying for an exemption number. And when we talk about the revised compliance and enforcement policy, you'll realize again the importance of having a license or an exemption number. There are a couple of drawbacks to having an exemption number. You may not want information about a product that you're working on in the database. As I mentioned, it's very basic information that will be registered in the database, but some companies may not want to disclose that information. International trade certificates are not being issued for products with exemption numbers, and as well, if you do have an exemption number, your product could be subject to an access to information request from a potential competitor. Again, with the APLAR, as I mentioned, it is a provision to make your product legal for sale, providing you meet certain criteria. It is a temporary solution to deal with unlicensed products. It will be repealed within 30 months of August 4th, 2010, unless it is extended. So in addition to the APLAR coming into force, this new set of regulations, there were a couple of other policies that came into effect that will also affect your market strategy and your ability to go to market. One is the application management policy. Again, this policy came into effect on August 9th of this year, and it applies to all applications received after that date. So there's some important things in this policy that you need to be aware of. The NHPD is increasing its standards for what they deem to be a complete application. And there will be a pre-review if your application does not meet the completeness requirements, if it does not have all the components of the application, such as label text, standards of evidence, quality information, it will be refused. So you need to have a complete quality submission going in. Before your submission can go in, though, you need to make sure that all your ingredients, whether they're medicinal or non-medicinal, are in the Natural Health Products Ingredient Database. An application will not be accepted if all the components in the formulation are not already listed in the Natural Health Products Ingredient Database. Now, there are a couple of guidance documents, again, that were released via BEEP, the email system, on August the 9th, talking about the classification of medicinal and non-medicinal ingredients and how to enter them into the database. Medicinal ingredients, you just need to demonstrate that they do meet the definition of a natural health product, i.e. that they belong in Schedule 1 of the regulations. And for non-medicinal ingredients, you need to demonstrate that they meet the definition of a non-medicinal ingredient, that they do have a purpose such as a filler or a binder, emulsifying agent, etc. For the medicinal ingredients, you do not need to prove safety and efficacy. That will be done with the product license application. So a couple of things have happened with the ingredient database. A large number of flavors were entered in conjunction with industry and the NHPD. There's also a generic term for flavor put into the ingredient database. So if you don't find the specific flavor that you're looking for, you might be able to use the generic term. And again, a BEEP is expected out about this initiative in the near future. It's taking them approximately 4 to 6 weeks to get ingredients into the database, so you need to factor that into your market strategy. Again, as I say, the standards are being ramped up for what defines a complete quality submission. Submissions should be submitted electronically. This is the route that the NHPD is going. In the future, electronic applications will be the only type of application accepted. A new version of the EPLA was released in mid-July. That's version 1.4.0. That should be the one that you are working with. Again, you can see that no early IRNs are being given out as well if a product application is either complete and accepted for further assessment, or it's incomplete and it's refused. So no early information request notices are being released. As well, the NHPD is encouraging stakeholders to have pre-submission meetings if you have any questions about what category your product falls in, if it's actually a natural health product, or questions about evidence that you may be supplying. So this is one way to make sure that you do indeed submit a quality application, is to request a pre-submission meeting.